Individuals who have been involved in certain criminal acts may be deemed inadmissible to Canada. This means that no matter how you intend on entering the country by car, plane, or boat, you will not be permitted entry. There are certain ways, however, in which a person can overcome a finding of inadmissibility and regain the ability to enter Canada. In this video, I talk about the steps that a criminally inadmissible person should follow in order to once again gain entry into the Great White North. Welcome. My name is David Jolly. If you are deemed criminally inadmissible due to a DUI or some other related or serious criminal offense and are interested in traveling to Canada, there is a process to restore your criminal admissibility. This process involves a number of important steps. Usually, foreign nationals or permanent residents will be considered inadmissible to Canada if they were convicted of a crime inside of Canada, they were convicted of a crime outside of Canada that is considered a crime inside of Canada, or they committed a crime outside of Canada that is considered a crime in the country in which the crime occurred and is considered a crime in Canada. Did you get all of that? Well, whether or not you are inadmissible to Canada may also depend on whether or not you have been charged, discharged, or pardoned for the crimes you committed. If you are found to be criminally inadmissible to Canada, you must then decide how you will attempt to overcome this finding of inadmissibility. The Canadian government suggests that rehabilitation should be the first method that all criminally inadmissible people pursue when attempting to overcome an inadmissibility finding. There are two main types of rehabilitation. The first is deemed rehabilitation, and the second is individual rehabilitation. There is no formal application process for deemed rehabilitation, as deemed rehabilitation depends entirely on how much time has passed since the crime was committed. You can, however, ask the Canadian government for an opinion as to whether or not you can be deemed rehabilitated. In order to apply for individual rehabilitation, the applicant must complete a number of forms, including a document checklist, application for criminal rehabilitation, fees for immigration services and approval of rehabilitation, and the use of a representative if you're going to hire an immigration expert to assist you with your application. If you are applying for an opinion on whether you will be deemed rehabilitated, there is no fee. With DUIs that occurred after December 2018, deemed rehabilitation will no longer be an option for future rehabilitation. If you are applying for individual rehabilitation, there is a fee of $200 unless the crime you committed is considered severe, which may then require an additional fee of $800. The final step of the application process is submitting the application with the required forms and payment of fees. You will then wait for far longer than what is reasonable to receive a response from the Canadian government. Once the application for criminal rehabilitation is approved, you will then be permitted access to our neighbors up north. If you are considering applying for criminal rehabilitation, it is highly recommended you contact a Canadian immigration attorney for detailed and current information. For more legal videos, please subscribe to this channel and read our blogs.